Ladies and gentlemen, it's a terrible thing to be made to feel uncomfortable every single day of your working life. To go to work with the knowledge that the guy who employs you and controls every single career prospect you have would like to make you feel uncomfortable with feeling you up and is verbally abusing you. This isn't kinky, it's actually very creepy. And so when one woman is able to bring a court case against someone as powerful as Mark McInnes, CEO of David Jones, we think that's a pretty powerful statement. It's really powerful because if that kind of settlement had happened behind closed doors, the public would never have known about the culture of endemic sexual harassment that runs in major corporations like David Jones. We think the kind of situation that we oppose today on this side of the House is out-of-court settlements, where bigwigs can just throw buckets of money at these women who are complaining about their rights, and the public, and making them sign confidentiality agreements to make sure this kind of knowledge never gets into the public eye. We think if this had happened in the David Jones case, Mark McInnes would still be there, prowling the corridors of his David Jones office. There wouldn't have been any public pressure for David Jones to change their processes. This is the exact kind of pressure and change we need across these corporations who have endemic problems. So what we support on this side of the House are these women who, when they feel that they've been sexually harassed and make allegations, for them to go to court and get a fair hearing before a judge in a civil suit. We much prefer this to be settled by judges, for these matters to go on the public record, to be talked about in the media, to be on the front page of The Age, to say these are the, and the Australian, if you don't come from Victoria, unfortunately most of you do. And we think that this makes the companies with cultures of sexual harassment, what they need is to be dragged through the mud, so no one can be able to hush these matters up and make them go away in a really convenient way for the head honchos of this. I have two main arguments to forward this case today. Firstly, why out-of-court settlements are not in the women's interests and the people who are being harassed. And secondly, how we're going to prevent systemic cultures of sexual harassment in these organisations. My second speaker will be talking about harms to the third parties. So moving on to this first point. We don't actually think that when you have an out-of-court settlement, when your head honcho takes you to the boardroom and asks you to negotiate with him, your harasser, we don't think this is in the women's interests at all. Because women don't actually consent to these processes or these outcomes when they're asked to make an out-of-court settlement. Why is this? It's because the kind of people we're talking about are probably not the CEO, the women who are sitting on the boardroom, probably talking about the secretaries, the PAs who've been abused, touched and threatened for years of their working lives, when their boss controls their income, any kind of prospect, and any CV that you can give them. And they basically control that worker, that woman. When that woman finally plucks up the courage after years of abuse to come forward and launch an allegation, what do you do with them? How do you best control them? How do you best give them the rights and the outcome they deserve? You don't put them back in the hands, no pun intended, of these corporate power structures and of these bigwigs who've been harassing them. We don't want them to be in those hands at all, because it's probably quite creepy, not very pleasant. We don't want them to be come to our boardroom and we'll see what we can do. Let's just throw a lot of money at you, get you to sign a confidentiality agreement, and please shut up about all those things that have been going on for years. That is an incredibly negative situation, because the firms and these bigwigs are the ones with enormous monetary power, enormous power to settle this. The power dynamics in that relationship stay the same. The power dynamics between a victim and an abuser. And when you get them to sit across a big oak table in the abuser's office, that woman does not have any power to fight for her rights. In all likely cases, the woman who's being abused probably doesn't know what rights she has. And when you're putting them across the table from a bigwig who probably has an entire law department on retainer, that is an incredibly intimidating situation. And we think the woman probably will be settling for less than she deserves, because she doesn't exactly know what she does deserve. Because when you're asked to settle out of court, you don't have people to talk to about it. You don't have people defending you in that boardroom. You don't have people to reference if you're getting a good deal and to see if your settlement is actually legitimate. And this all changes when you put that woman and you put that CEO in front of a judge, because we think the judge can look past the tactics of flashy QCs who are being hiring enormous salaries to try and defend the public face of a company who's been harassing systematically its employees. We think this leads necessarily to fairer compensation for the women themselves. To the extent that we think this court process is going to be traumatic for alleged victims, we don't think this is necessarily the case. Perhaps it's not pleasant to have to sit in a courtroom and hear your history of abuse being retold in front of an entire courtroom and before a judge. We think this is a civil suit, and it's important to distinguish that from a criminal suit, because it means you're not going to be asked to cross-examine, to advance evidence, and to stand in front of your abuser and try and defend yourself from it. We think what is much more stressful for that woman and much more traumatic is to ask them to sit across an oak table and negotiate with your abuser, who has all the power in that relationship and has had for years. That is traumatic. That is horrible. That is not what we want. Because you don't have someone defending you as you would in court. If you think like if you're going to be intimidated in a courtroom, that is where the judge steps in. That is where your defense lawyers step in. That doesn't happen when you're asked to settle out of court in a hushed up situation where it's like dealt with internally within a company. We also think there is an ancillary benefit, and it's quite an important one. And that benefit relates to like the other women in the company. So we bring you back to the example of Mark McInnes. These kind of like behaviours of sexual harassment doesn't happen once, doesn't happen to one woman. They are patterns of behaviour. So I think it's very likely that there was more than that, just that woman who had the courage to come forward and launch that case against him. What happens when you have like these cases out in the open and you have like the entire media slamming some guy for like his horrible practices? You give other women in the company who may have also been victims of that person the courage to come forward. The case like of out-of-court settlements means that this entire situation is hushed up. You're like signing confidentiality agreements, asked to like swallow huge amounts of money, and please sit down and shut up about what has happened to the abuse of those last few years. That doesn't give other women the courage or the knowledge they can come forward and receive appropriate settlements. So that moves me on nicely to my second point, which is about how to prevent systematic cultures of sexual harassment in organisations. Like I told you, we're mostly talking about big corporate businesses. We're talking about endemic like boys culture networks where they back each other up and try and keep their friends on the paywall and try and like hush up any allegations or scandal that is going on around them. So we think that how a company reacts when you're like allowing them to have out-of-court settlements about their sexual harassment cases is really different. What happens is there isn't any public pressure to change the culture. There isn't public consciousness or outcry about how we don't want to like be supporting that business because they're being really horrible to their employees. There isn't any image loss. This changes when you have a court suit because it forces the company to take action to try and not be seen as abusive or misogynistic. There are four main ways in which we think will force them to take action. Firstly, it means you're probably forced to fire the person who has been being launched against and had allegations of sexual harassment against them. You're also likely to be forced to investigate internally into that company, to make public announcements of that behaviour, and to change company power structures to incorporate more kind of female-friendly or things that are against sexual harassment. Why wouldn't companies do this unless you are publicly forced by the public outcry against the behaviour in your company? Two main reasons. These things are really time-consuming, and every hour or day that you put towards anti-sexual harassment schemes and structures in your company is hours a day that is spent away from your direct power and your direct profit motive. We also think that it is manpower. You have to hire investigators to launch into your company, and that is expensive and also time-consuming. Why does a court actually force them to make these changes? We think these are the changes that you need to solve these systemic problems with sexual harassment in these companies. Firstly, it means your name gets dragged through the mud. David Jones did not have a good reputation at the end of that court case, and because they didn't have that representation, there was a profit motive for them to be back on top and to be back making profits when they made these changes. We also think it affects recruitment, because if you're seen as a company that's misogynistic and bad against women, men who don't like those practices, and also women, are much less likely to stay in your company or try and enjoy it in the future. Ladies and gentlemen, this is a serious issue. We think the only way you can ever change these practices is to force companies to take these steps. That only happens when you have very public court cases with guardian folks.
Ladies and gentlemen, in this morning's debate, the negative side understands that the most important person, the most important stakeholder in this situation is the victim. The person who's been violated, the person who's been intimidated. That's where we have to consider what they want. The choice of whether they do want to be a martyr, whether they want to be thrown out on the front page of newspapers and being forced to instigate change in different companies, or whether they want to keep this private, this emotional issue that's close to their heart, what they want to do about it. Because these are the people who have actually been violated. These are the people who actually need defence. So we understand that these are the most important people in the situation. And the allegation right from the start in the affirmative side that we're going to get this powerful statement, with the example of David Jones, we're just make it clear that the negative side we're running the status quo. We're happy with the way it works at the moment. And the David Jones allegations did come forward. People still will settle things in court under our model. That's something we're very happy to say. That we've got the best of both worlds. We've got people settling out of court and in court as they want. Okay, so I've got two main points of rebuttal, two main things. This idea of consent, and then the idea of trauma, both to the victim itself and possible future victims. So consent. Alright, so we had a mischaracterization right off the bat from Beatrice about what's actually going to happen in these out-of-court proceedings. Like, she wanted to talk about the hands of the CEOs and stuff on this oak table and things like that below. Like, we think it's just wrong to say that these people won't have legal representation. Like, the access to justice in Australia is pretty good, and it's not true that they're going to be forced to do these kind of, they're going to be forced to do these kind of, like, negotiations by themselves. We also, question the idea of whether, if these things are so intimidating, if it's intimidating for people to come forward, into these boardrooms, then it's going to be just as intimidating to come forward into a courtroom. And this is something I'll talk about for later in my substantive material. On this idea of judges being able to look beyond flashy QCs, that's just not true in the sense that these flashy QCs are flashy because they're good. They hire people who are good at convincing judges. That's what makes someone a flashy QC. And so the very nature of judges being A-group lawyers who are good at what they do isn't true. And when there's a power imbalance, when these people are able to hire the best lawyers, that's when we're going to get a bad outcome. On to the second idea of trauma. Okay, so it's similar leading onto that idea of how it's bad if you get intimidated in the court, intimidated in the boardroom, and the legal representation of the big company is going to smear your name and intimidate you. I think it's going to be just as bad in a courtroom itself, when they get the opportunity to air everything that you've got, air everything that you don't want to be aired. The situation's going to be similar in the sense that they're convincing a judge or trying to intimidate you. They're still going to do the best they can to discredit what you're trying to say. And let's ignore the idea that the idea that it's more traumatic in a boardroom. Ignore the analysis coming from the first affirmative herself that these things are going to be on the front page of the newspaper. That's traumatic itself. To have everybody know what's going on, to have something you probably you may or may not have wanted on the newspaper in the front page, with everyone you see saying things about it to you. People might not want to come forward, and we think that's an important issue. The same analysis works for this idea that these women should be the assertion that these women should be responsible for changing companies. They should be responsible for making these places more female friendly, and that by coming into court cases they're going to be able to fire people who are misogynistic. We think that's a good thing. We think that's we want these things, but we don't think people should be forced into these positions. It's the idea of harassment comes forward again. We don't want these people to be forced into these situations when they don't want to, when it's not their choice and it's not something they want. Okay, so substantively, I've got 2 points: the harms of the court system, and then secondly, how out-of-court settlements can do these things together. On this idea of the harms of the court system. And on the negative side, we see that it's impossible to decide what someone wants. The government can't just step in and say this is what these victims want. Because they know best for themselves. They're in a position to decide what they want. And so everyone is different, especially in the cases everyone in these kind of cases are going to be different. The affirmative side only wanted to talk about the high-profile cases, the cases about CEO David Jones. We've also got to consider the people who just get sexually harassed on a lower level, maybe on a lower level, but not by someone who's such a high-profile person. And not someone that's going to attract so much interest. We've got to think about what they want and whether they want their issue to be out in the newspaper, to be known. And so this is the idea that we need to prioritise victims. These are people who've been harmed. These are the people who have an issue, who deserve this kind of compensation, and their needs need to come forward before anyone else's. Alright, so a couple of reasons why the courts are so harmful, and why that means we need to prioritise the victims thing. First, this idea of courts being intimidating. It's so much more adversarial than anything else. It's not negotiation. It's not happy. They're both out there trying to convince a judge. They're going to be airing secrets a personal invasion, a personal invasion, and it's quite traumatic. This is just the nature of sexual crimes themselves, being a traumatic experience, something you probably don't want to relive. And another reason why courtrooms are so harmful. You've got to think of the idea of what they actually want out of this situation, what the victims are actually thinking about. And it's not necessarily that they want everyone, other people to not go through the same thing. Some people might, and that's why we give the option to go into a courtroom. They probably just want closure. It's probably been a long-term issue. It's probably something that's going on for a while, and they just want it over and done with. They just want the finality that this isn't going to happen again. This person, has admitted they're wrong, and it's not going to be tied up in anything more. And you get that just as well in an out-of-court setting. Finally, onto this idea, quite quick, because I mentioned it before, the idea of forcing them into martyrs. The affirmative side really wanted these people just out of, even if they didn't want it, to forced into the spotlight, to be the people who standing up for a crusade, even if that wasn't their thing, even if they didn't want to represent people, suspending their desires, suspending their needs when they're in this vulnerable state, and so for the good of people. And we don't think that's right. We don't think these people should be forced into a situation that they're not happy with, because their needs need to be prioritised. On to the second point, how out-of-court things can be better. Now, like I talked about before, like, it doesn't require a statement, it doesn't require people to come out there and say things, and you still get legal representation. But what out-of-court settlements do, like, is if you don't like the negotiation, if your lawyer hasn't been able to do a good enough job in the boardroom negotiation, then you can still go into court. Like, you can go into court and, like, you can suspend the negotiation and say, no, I want a judge to decide this thing. So you still get the benefits the affirmative side want to talk about. But we've got to consider that it is hard to prove these kind of things in court. Like, there's a couple of reasons for this. Like, the very nature of sexual harassment crimes means they're probably done behind closed doors. There's probably not that many witnesses. Like, it's hard to prove these things, and like in serious civil things, it's not going to be proven on like a balance of probabilities. They've got to consider it in light of, like, you know, people's reputation and what's going to happen post the court case. And so, if there's any doubt at all, and we think this is quite likely in this situation where it is quite, like, you know, private. It's an unfair burden, basically, on the victim. It unfairly, like, burdens the victim in the sense that court cases advantage the people with more money who can hire, like, the better lawyer. In that sense, and we think, like, quite often with these crimes, it's done, you know, by a person in a position of power, so they are going to be in a better position to get that QC. And then secondly, the idea that just they're in a vulnerable position. Like, this is a seriously traumatic thing. Like, it's they can have, like, you know, flashbacks, like, don't really want to remember it, and when they're, like, you know, being examined, or, like, you know, when they've got one little inaccuracy in their recollection of what actually happened in this, like, horrible situation, then we think that's, like, you know, could be catastrophic to a court case. It makes it, like, you know, they can't prove it. If it's just one little thing, then, like, lawyers will be able to pounce on that. And we don't think that's bad. We don't think that's fair. We don't think it's equitable. People just, like, get, like, you know, one little bit that they haven't remembered correctly to be focused on in a court case like it can. So, like, when you don't get the opportunity for any other kind of remedy, when you're forced into one situation, we think it's, like, much better just get the opportunity to choose. The idea that you can go sell it out of court, or you can sell it in English court, and it's the victim who gets to decide.
Ladies and gentlemen, the real question following Andrew's speech is this. When are misrepresentation and fancy lawyer tactics and the quality of the name of the lawyers that you have more likely to play into the actual outcome that operates? Is it more likely to happen in a courtroom where you have a trained judge who deals with those things regularly? Or is it more likely to happen in a boardroom where you have a victim who probably isn't that aware of their own rights? We tell you it's much more likely to negatively affect the outcome in a boardroom. But also, even if, Madam Speaker, we were willing to concede this is better for women, obviously we're not. But even if we were, we heard no engagement from the negative about the balancing act that operates in this debate. Because this debate, unfortunately, isn't just about individual women who come forward and need compensation for sexual harassment. This is about every other woman in that corporation who may very well have been sexually harassed, who doesn't have the power to come forward without these cases being on record. This is about every other woman in society who's affected when we don't hear about sexual harassment that happens in these corporations and we never do anything to change these corporate structures. They need to tell us why this individual woman is the trump card in every single instance in this debate. I'm going to ask two questions and I'm going to integrate my substantive rebuttal. First, what is best for these individual women? And secondly, what is the fair balancing act between these women's rights and the rights of other victims, future victims, and the rest of society? Okay, let's talk first about these women. The way Andrew was speaking, you would think that the only reason these court cases were not taken to court and the only reason they were kept in the boardroom was because it was better for these women. Because these women didn't want to have this stuff in like the public sphere. With no engagement in terms of the power dynamics, about who makes the decision to keep this in the boardroom. Because we don't think that it's accurate that women ask to keep these things private in the majority of circumstances. We grant that it certainly does happen, but we don't think it's the number one factor. We think largely what happens is women would bring forward a claim to whoever is the authority in that particular corporation, and that person refers that claim on to the CEO or refers that claim on to someone in a high position who then says, don't you think it would be better to keep this internal? Don't you think it would be easier and quicker and more beneficial to keep this internal? We don't think this is these women coming forward and saying, we don't want this to go public, we want to keep this as private as is humanly possible. Let's deal with the four different points of analysis we heard from Andrew. First of all, he said these women do have legal representation in these boardrooms, meaning that there isn't problematic outcomes there. First of all, that requires them to seek representation. We think often the way these CEOs or bigwigs in these corporations actually present these things to these women is to say, it will be quicker and easier for you if you do not bring lawyers into the mix because we can to negotiate this privately, and that's ultimately going to be a better thing for you. We think that means that oftentimes they do not actually have legal representation in these out-of-court settlements. But let's assume for a second that they do seek representation. What does that representation look like? Andrew acknowledged that to some extent, even in a court system, there are going to be better lawyers and worse lawyers. That the CEO is going to be represented by Minter Allison and the other person is going to be represented by legal aid. We think judges are much more able to overcome that distinction than those individual people are when they're sitting across an oak table from the entirety of the partners at Minter Allison and they've got legal aid guy John. We think that means that they are less likely to actually engage in that discussion. We think courts are much more likely to be able to overcome that, even in the instance they have representation. What else did Andrew say? He said, this process is more adversarial because you have to get up, you have to prove yourself, and you are in direct competition against this person. Couple of things, Madam Speaker. The process of a negotiation is completely adversarial when you are on direct opposite sides and you are trying to negotiate with the person who abused you. It is far simpler to say that it is not adversarial. But secondly, let's look at the types of things that characterise these processes, Madam Speaker. Because they are kept secret, because oftentimes they do not have legal representation, there are all kinds of things going on, like actual bribery, also like threatening these people with the loss of a job, with not providing a reference, with not actually allowing this person to ever move up in that corporation. We think those things play into these particular processes in a way they never would in a court system. Thirdly, on the outcome, he said judges listen to big, flashy lawyers just as much as anyone else, and also you won't get the right outcome because this is hard to prove. It is incorrect, negative team, to say that this will not be decided on the balance of probabilities. It absolutely will. It is not true that judges are out to protect the reputation of corporate bigwigs, as Andrew literally said. We think judges are there to get what is the best and fairest outcome for the victim. To the extent that they play into big flashy tactics, once again, you need to show us why that is less likely to happen in your scenario than in ours. We think you will get a more fair payout under our system. Final piece of analysis here, making the front page of the newspaper and how traumatic is that for these women. First of all, Madam Speaker, we need to actually analyse what the story says on the front page of the newspaper. Because just having your name in public, we acknowledge can be traumatic, but we don't think is the only part of the analysis. We think what happens when these stories hit the front page of the newspaper is significant parts of society come out and defend you. Because actually the front page of the newspaper says, Mark McGuinness found guilty of sexual assault. This is endemic in David Jones. This was not your fault, person who got sexually assaulted. This was David Jones's fault. This was Mark McGuinness's fault. We think that means you actually get public support that you would never get under their model because you never ever hear about those things. So in terms of closure, we think we take that as well, Madam Speaker, because you get to see that person be fired. You don't have to sit in that corporation for the next 10 years and watch Mark McGuinness go on and live his life as if nothing had ever happened. We think we are allowed to, we actually win that argument as well. So ultimately, we think this is better for these women. We think they're going to get more money, we think they're going to get better closure, and we think that that is really important. But let's talk about the instance where it's not. Let's talk about the woman who really doesn't want her name in the newspaper and who ends up with a really dud lawyer who gives her less money than she would otherwise have gotten. Because this debate, Madam Speaker, is about third parties. There are two third parties. First, other victims. We heard no response from Andrew to our analysis about how this actually empowers other victims of that very same person in that corporate structure to come forward. We think that's an incredibly important stakeholder. But secondly, let's talk about the rest of society. We think the state should absolutely attempt, where possible, to restore the victims of sexual assault to what they were like or how they lived beforehand. I think there are limits to the ability of our system to do that. We think, therefore, the state's number one interest and also its most utile actual position in this situation is to prevent future crimes against these victims. We think the way you do that is by firing these people, Madam Speaker. The way you do that is by changing the corporate structures that enable these people to live like they do, that enable this type of boys' club culture that actually endorse sexual assault. But we secondly think the interest of the state is to have these things publicised so there is an accurate understanding in wider society about what the scale of the problem is of sexual assault. Because what does the negative team do in this debate? They artificially change the perception of the scale of this problem. Because we don't have to hear about it as much, because we don't have statistics, so we can ignore it as a society, Madam Speaker. We told you it is incredibly critical to have these things on the front page of the paper, because they increase discourse in general, not just within that actual corporate structure and creating change there, but in general society about how pertinent these problems are and about how often these things actually occur. That forces change to an extent we think is incredibly important at preventing these crimes in the future and changing the actual discourse around sexual assault and changing the way people relate to sexual assault.
We think those things are critical for society. We think they're critical for future victims. We think they're critical for other current victims of sexual assault or former victims of sexual assault to make sure that those issues are dealt with meaningfully. So what was their response? They simply said, we will get some court settlements anyway. Madam Speaker, that didn't acknowledge the wealth of analysis we brought you about why it is in the interest of these people to avoid court settlements. We agree there will be occasional court settlements, Madam Speaker. We think they will be rare, which means you do not get the same mass effect as having these things regularly brought forward in the newspaper. Madam Speaker, we do what's in the best interest of these women, but they are not the only stakeholder that the negative action needs to engage with today.
Madam Speaker, we have out-of-court settlements right now, yet we still have women coming forward and taking people to court and having high-profile cases. Their own example of Mark McGuinness and the David Jones case was still able to occur despite the existence of out-of-court settlements being an option for those victims. We think you get all the discourse they're talking about under the status quo and what we're talking about. That incredibly high-profile case garnered the discourse and the social discussion that they were looking for despite the existence of out-of-court settlements. We don't think out-of-court settlements have done anything to harm that. We think what they do is give greater access to the kind of justice that is most appropriate for that individual victim and their individual case and what they best see as would be the most appropriate remedy for them if they want to take that particular route. So I'm going to look at a few different things in rebuttal in terms of looking at the effect on encouraging other women maybe in that corporation or just other women in general or coming forward, how companies are going to respond to this kind of system, and will this actually make the system more fair. What I'm going to be looking at in substantive is what actually creates a social change when you're talking about sexual harassment. Let's look at this first rebuttal point. What is going to be the effect on encouraging other women to come forward within that corporation? We don't think necessarily that other women are going to come forward just because one woman did. We think that individuals obviously have personal reasons why they do or do not choose to come forward on something that is this personal and this private. Maybe it is because they've been intimidated, but we think in a lot of circumstances, it's because it's incredibly personal and it's something that maybe is embarrassing for you. Maybe it could be embarrassing for your family. Maybe you think that there are other things that are more important or other things you want to balance that against in coming forward. So we don't think automatically you're going to get more women coming forward. But we think also their premise is contingent on having women all taking up that option of going to out-of-court settlements anyway. In terms of what happens to the companies and how they're going to respond to this, that we were told by Gemma that companies try to squash this. They try and keep it internal. If someone comes forward to the legal department, they say, no, let's just keep it internal and we'll deal with it. We think that that could probably still happen under their proposal, Madam Speaker. We think that when you come forward and make it public, try and attempt to do something about it and make that intention known, we think that there's definitely the possibility of intimidation, of that legal department or the powers that be within that corporation trying to sway you or recharacterise what you thought happened, trying to explain maybe the intent was different, or trying to dissuade you from going forward with that particular case. So we think that the harms of, say, no references or demotions or things like that very much still could exist and used as threats to try and discourage those people from going forward with that court case, which would then mean that individual then gets no remedy as opposed to some kind of remedy they would get if they had the option of going through an out-of-court process. We think that's particularly important because we don't think you can mitigate all the harms that they talked about coming from the company by cutting off another option of access to justice. Let's look now at this last point of rebuttal. Is the system going to be more or less fair? We think that the type of remedy that you are seeking is particularly important. Some people do want to be able to make this incredibly public and do make a massive, maybe they are trying to make a massive change and they are willing to be the woman who has their name in the paper. Maybe they are willing to do that. We think a lot of people aren't looking to do that though. A lot of women don't want to be slammed as that whore that's in the paper because a lot of people did think that about the woman in the David Jones situation. Not everyone felt that sympathy because people had different interpretations. For sexual harassment, it was very hard to prove, and he had his own case that he was able to try and say that he didn't do anything wrong. So we don't think that every woman wants to come forward like that. A remedy that a lot of them want is just some kind of recognition by that individual that they did something wrong. That recognition still comes when they get that compensation, even if it is a lesser monetary compensation, when they still have to pay out. We think that remedy and the acknowledgement from that individual that something was done wrong and that you have been proven right in that compensation, and you get that closure and you get it in a timely way, is particularly important, and that could be what is most satisfying for that particular individual. And we shouldn't cut off that opportunity and leave them with no remedy as opposed to some kind of remedy that may exist for that person. Now I want to look at what actually creates social change when you're talking about like sexual harassment in these circumstances. So the opposition obviously want to use these employers to try and create change within a corporation. Obviously this is contingent on women coming forward. And we think that obviously there would be a big problem, or could be a big problem, if this is their absolutely only option, when they may not want to come forward, and that might not be the remedy that they're looking for. They want to look to retain privacy. Maybe they want to stay in that workplace. Maybe they're happy to continue working there once there has been an acknowledgement of that situation and something has been done about it and the company's recognised it. Maybe they don't want the infamy for the rest of their lives as being that woman who was sexually harassed by the CEO of David Jones. Maybe they don't want to have to go through those particular circumstances. So we don't think that necessarily we should be encouraging a situation where the way we get social change is by putting women up as martyrs for the cause. We don't think that that's the most appropriate. We particularly want to look at, let's look at the nature of these crimes. They're obviously a kind of crime where that victim has had no control and no power in the circumstance. We think you're further reducing their ability to have control in that situation and circumstance when they lack the ability to determine the outcome of that, when they can't decide how they're going to remedy that. We don't think that does anything for changing the discourse on these being helpless, or like unable to do anything for themselves kind of victims, by further undermining any kind of power they have in that situation, when they can't determine how they want to get an outcome, and they can't determine the best way to move forward on that. We don't think it does any sort of encouragement for changing that kind of rhetoric that exists around those particular kinds of victims. I think that's incredibly dangerous for those people. If it works exactly the way they want it to on the opposition, we think that means you're probably going to, and we have lots of women coming forward and lots of sexual harassment cases and lots of discussion about it. We think that could be harmful in the terms of perception, because we don't think sexual harassment actually probably occurs all that frequently. The media is very good at blowing it up to look like an incredibly big story. So the circumstance of David Jones, that was obviously a massive story, but really it was about one company. We think it could be harmful creating a social panic in terms of how people perceive their workplace, whether or not they see it as a secure or cohesive working environment. Because then it's in the media and a big case makes it look like it's a massive problem, despite the fact it may be an isolated incident, but it just happens to be a particularly famous isolated incident. So we think creating a social panic around those kind of concepts doesn't do anything for changing the discourse on sexual harassment. It doesn't do anything for making people feel more secure within their workplace. If it doesn't work, we don't think you're going to obviously get anyone coming forward and getting any kind of social change. And we think that's probably more likely. We don't think that a lot of women are necessarily going to want to come forward and not going to want to be the kind of mind they're talking about. We think a lot of women just want to be able to move on and get some kind of closure, and that's the best thing for them. What we absolutely think, Madam Speaker, on this side of the House, is that we need to make sure we give the best access to these victims, to be able to have the kind of justice that best suits them in their individual circumstances. We don't think it is the position of the state or of the law to determine what remedy would best suit an individual case or an individual or a person's particular circumstances. We don't think that's their role. We think their role is to give the greatest access to accessing the kind of justice that would best suit you. So we want to be able to keep options open and allow these individuals with options to go to court and take on all the burden of being a martyr for womankind, if that's what they really want. Or they can just have some kind of closure and a remedy and acknowledgement of the situation, because that's what best suits them. So Madam Speaker, we beg to oppose.
Ladies and gentlemen, if we do not allow this motion to stand, corporate bigwigs are going to remain insulated from their crimes. How has what the negative said today proposed any alternative to ensure that this is not going to happen? How are they going to get rid of sexual harassments within corporate organisations? That is the question that we ask, because we have had very, very little engagement on a critical level with that substantive material that we provided in relation to both society and corporate organisations, and how we're going to actually clean up this problem, and how the two situations are not just in relation to the victim themselves, but society to a wide extent. So I'm going to split the two things in this debate today into what is best for the individual victim, and then what is the best way to eradicate sexual harassment in wider society and corporate organisations. So first, beginning to engage with what the first speaker spoke about in terms of trauma. He spoke about the trauma of sitting in court itself, seeing yourself in the newspaper and your crimes publicly in the newspaper, and the fact that during these court proceedings you'll have flashbacks which will bring back bad memories, etc. Now, we agree that court proceedings may not be pleasant, but you have to ask yourselves which is more intimidating. Sitting in a court, a transparent public place with other people around you, court officers there, you actually feel like this is a legitimate process. Or sitting in your old workplace, as my first speaker said, across an oak table, looking your harasser and his cronies in the eye and seeing the hands that harassed and touched you across the table. We think that the court system in this regard involves much less trauma than was said. The second speaker brought something new about this just then. She says that the paper calls these people whores, and this is one of the most traumatic things about the system. Now, even if this is true to some extent in the most far right wing of newspapers, if this occurred, there would be an absolute outcry from society. If these women were demonised in these papers, there would be an absolute public discomfort. And the fact is, at least these crimes will now be in the consciousness of the public, and that this outcry will prove something that ensures that these women in the future may not be harassed, because endemic cultural problems in these organisations will not be accepted anymore. They spoke a lot about the victim's choice and how a victim ought to have the choice in this situation to decide what is best for her. Now, firstly, we do not think this is really a choice, really a proper choice, because of the significant pressure, firstly, from the boss themselves, because of the money that they have and the fact that they want to keep it out of the public consciousness. We can't underestimate this pressure, ladies and gentlemen. When these vulnerable women are sitting across the table, we've already spoken about how they don't have the great legal representation in many cases, and the great skills to actually determine what's the best thing for them. But the bosses themselves have so much money at their disposal that they can throw it out in this situation, not leaving the women with any actual choice to determine what would be the best thing for her. But even if there is consent, ladies and gentlemen, we strongly believe on the affirmative that they shouldn't be allowed to agree to these out-of-court settlements, because not only will they not get a more proportionate outcome, but there will never be that public pressure to change the culture in these organisations. And that is the absolute crux of this debate, ladies and gentlemen, because the negatives have not proven how this culture will change under their model/proposal. They also spoke, the second speaker, about the negative methods that occur within these negotiations and the bribery, and they addressed this aspect of our substantive material that we proposed, and they said that this would still occur under our model in certain circumstances in relation to the court proceedings. Now, this is actual corruption, ladies and gentlemen, and we think that this is something which needs to be targeted separately, and it's important to note that the status quo allows this to happen anyway. So it's already redundant in the fact that the negative for proposing no change to this system where this corruption already occurs. So now moving on to really the main focus of our case today, not only the victims, but what is going to happen about the endemic culture within these corporate organisations. We heard from the second that currently women come out under the status quo, and that these people who are coming out in the future will have the same effect as the DJ's case, and that there's no reason why these women will not come out in the future and won't have the same effect as this David Jones case had. Now, what the status quo requires, ladies and gentlemen, is an extremely confident woman, an extremely dedicated, self-confident person who is willing to go before this process and deal with these bosses. Under our system, we are allowing a far less traumatic, etc. proposal whereby they do not have to be as individually strong. They can feel like there have been so many women in the past who have done these things and have been successful because it's in the public consciousness, that they will actually have a chance. The women under the status quo who are coming out currently are fighting against a tide in which women have had these things settled out of court and they have not been recognised as women who have got what was proportionate to them. Also, sexual harassment under the status quo looks like it's an anomaly. It looks like there are actually very few cases where this sexual harassment occurs. And we fundamentally believe that this is not the case. There was recently a survey at Monash, funnily enough, where 75% of women surveyed by the MSA said that they'd either been made to feel uncomfortable by a man in the last 12 months or been harassed. Now, of course, very, very, very few of these things would have actually been, say, relayed to an equity officer or etc., or relayed to any sort of formal court system. But they do occur, ladies and gentlemen. And we think that this situation at our university is very analogous to the workplace. There are so many instances where this occurs, and it is simply swept under the carpet and not realised by anyone to be a significant issue because these women are not confident in coming forward in the first place, and they don't think there's any chance of justice. And so, what the first speaker initially said in this case was that heaps of women still won't come forward even under our proposal. So specifically they were saying that even under the AFS model, we're not going to significantly change this fact. However, if you put these women and force them to go through the court system, it ingrains the idea within everyone in society, as well as these women, that there is a process, a reliable process, whereby they will get justice. Negotiating with your boss across an oak table, even if the woman thinks it possibly could be a better outcome for her, she certainly is not certain of the fact that she is going to get a transparent, just process by the system. She may think she's going to get a better outcome, but she doesn't think she's going to get a better process necessarily. So that's why it needs to be in the courts, so these women will come forward. Lastly, the second speaker spoke about how the media generally overstates the multitude of this sexual harassment. And I've already spoken about in terms of the Monash survey and etc., how we think it actually happens quite regularly, very regularly. But not only this, but it's an endemic culture that we currently have whereby these crimes, ladies and gentlemen, are kept quiet. These crimes are not relayed to the people who can ensure that the best outcomes occur for these women. And that's the crux of this debate today. It's the best outcomes for these women, and it's the best outcomes for the women in the future when they get sexually harassed. We're proud to propose.
Ladies and gentlemen, tonight the pivotal question this debate hangs upon is, do we believe that respecting the rights of victims of sexual harassment to choose the avenues of resolution of seeking a just outcome, is that the best way to remedy sexual harassment? We as the negative team are proud to support this, and that is our position, because we simply believe in empowering the rights of women to choose the way in which they seek justice, and we believe that offering both flexible avenues of out-of-court settlement in addition to the traditional forms of pursuing court settlement, providing both options is simply the best way to remedy sexual harassment. So I've identified two main themes today in which I will break one into sub-themes. So my first theme is basically which environment is the best way to achieve just outcome. So within this theme I've got looking at the benefits of why an out-of-court settlement will actually allow a just outcome to arise, and then furthermore also what are the negative impacts of the court environment and why it will not necessarily lead to the just outcome like the affirmative team proposes. And secondly, my other theme is looking at cultural change and what is the best way in which to stimulate and instigate such cultural change of attitudes against sexual harassment. So on to my first theme of looking at the benefits of out-of-court settlement and why it is that we still endorse the existence of such an avenue for victims today. So the opposition have come up with the first primary notion of the fact that that an out-of-court settlement will automatically or most likely lead to a less just outcome because victims will most likely be courted into signing a confidentiality agreement or just simply receiving a payout of money. Now firstly, there are three main points I want to address with this particular argument that I believe simply make it not legitimate. So firstly, we don't believe necessarily that limiting the avenue of resolution to just the court system will necessarily provide this just outcome they are seeking to achieve, right? Like, there is no guarantee that the court can actually deliver something more than something that the victim wants. Firstly, because there is still a high burden upon the victim to prove a sexual harassment case. We recognise the fact that these cases are often very hard to prove simply because you don't often have many witnesses who actually witness this sort of thing. And it often happens behind closed doors. It's not necessarily easy to prove like other crimes. And because of the difficult nature of this crime to prove, we believe it is actually in the best interest of the victim to choose whether they decide to go to the courts or stay out of the courts. And secondly, if you're characterising the victims of sexual harassment, whether they are long-term sufferers or whether they are short-term sufferers of such detrimental treatment, neither of those two types of victims are in the psychological position to actually go to court and prove and meet the burden that they are expected to meet, that crime actually happened. In both cases, they will most likely be traumatised. They will be emotionally vulnerable. They will be in a state where they are used to being in that inferior position, in the inevitable power imbalance you have in the crime of sexual harassment. So for that very reason, we don't believe that any victim is necessarily in the psychological position to do so. Having said that, should they be in a psychological position to actually prove their case in a court environment, the whole benefit of our model is the fact that we provide that avenue to go to out of court and also to pursue court. If they are so ready to do so, we provide that avenue of court settlement rather than quartering them into it inappropriately, like the opposition proposes. So secondly, even if such an outcome of a confidentiality agreement and a big payout arises, even if that is the outcome that an out-of-court settlement can produce. Let's just examine exactly what is it that the victims are looking for. Obviously, they're looking for an outcome that will remedy the sort of detrimental treatment they have incurred and the harm that they have incurred. But it is also about the process. It is not necessarily just about the outcome, like I want to see him get fired, like the opposition believes that victims want. It's not all about saying I want to see punishment for this person that has harmed me for so many years or months, right? Like it's also about the process in which you gain that outcome, and that process is very important when you compare out of court and court settlement. Court settlement is often very drawn out. There is no limit of time to which that resolution would necessarily come, okay? If you look at the court process compared to an out of court settlement, it is not as accessible in terms of financially because of the need for legal representation. Secondly, it's not accessible in terms of time, as I have just discussed. And thirdly, just the adversarial nature of the court system, which I'll elaborate upon, simply does not make it the ultimate best avenue for all victims to go through, which is what the opposition proposes, right? So the affirmative basically corners and forces all victims of sexual harassment to pursue this intimidating process of court procedure, right? So just examining what the harms are actually in this case, you eliminate the integral benefits that victims can derive from out-of-court settlements by removing that completely. You cut out that option for people that would actually want to pursue that option, okay? And secondly, it's not as if that our model is completely eliminating the benefits that court settlement can provide. We provide both avenues. If one fails, like out-of-court settlement, you can pursue the other, right? Under the affirmative team's model, there is just court settlement. If that fails and they do not attain the remedy they need, they have no other option. It simply fails. So onto the negative impacts of why, within this thing, why it is that the court environment is so detrimental in terms of if you're going to apply it as the blanket solution for all victims of sexual harassment. So I've already discussed the intimidating nature of the court system, and the opposition has simply failed to really acknowledge the fact that this intimidating environment does not suit all victims. And applying it to every uniform case is not the best way to do so, right? So there's a notion under that defence lawyers are there to decrease the intimidating atmosphere of the court system for victims because they're there to intervene on the victim's behalf where they understand if they're being battered. So firstly, we don't believe that having a defence lawyer is necessarily going to eliminate the intensity and adversarial nature of the court system, right? The victim, regardless of what type of legal representation is present and the quality of it that they are against, they're still forced to be on the stand. They're still forced to give their testimony and recount traumatic experiences they never wish to actually tell anybody. And they're actually forced to relive that experience when they do not necessarily have to do so. An out-of-court settlement does not put a victim through such traumatic experiences. And it's the fact that we give victims both those options that we believe are in the best interest of the victims, right? Secondly, within this theme, the second notion is the fact that in a public case, when you're putting it in the open, you are allowing the perpetrator to tell their side of the story, right? In front of a judge, in front of the public. And in this case, it is harmful for victims who are then going to be publicly vilified because of the type of crime that is really hard to prove. You get a perpetrator going in depth into what exactly it is that they did and caused all this detrimental harm. And we believe that's simply not in the interest of the victim. So on to my last theme of what is the best way to actually instigate cultural change and the changing attitudes towards sexual harassment. So firstly,
We believe that already the status quo as it stands, by providing both out-of-court settlement and court settlement, we are already getting that cultural change. And why is it that we believe providing both avenues is actually going to instigate that? Simply because you are making or you are allowing the process to still remain accessible for all victims, right? Like you basically, like with the opposition's model, if you're going to eliminate that option of out-of-court settlement, you're most likely going to discourage victims from coming forward because not every victim, as I said before, is not in a psychological position to handle the stress of court procedure. And for that reason, we believe that victims of sexual harassment are actually more likely to cover it up and not actually come to court, and probably not as likely to want to address it in the open because they have to go through this intimidating court procedure that I previously outlined. And secondly, we believe that the way in which that the opposition wants to achieve this change is not necessarily a good thing. You are harming victims by only exacerbating the tension they already are experiencing in order to attain publicity for a cause that we believe is already getting enough attention as is in the public sphere. So for that very reason, we respect the rights of victims in these types of crimes, and we believe that is why we are proud to propose.